Hello and welcome everyone to the 7th episode of 1,000 Paths to a Career in Arbitration. For those who don't know me yet, my name is Mandy Lee and I am the founder of Careers in Arbitration. And now, before I turn the floor over to our host with the most, it's my job to make a quick housekeeping point. We will be, and in fact we already are, recording this webinar. We ask all participants to kindly make sure that their microphones and videos are switched off during the webinar. Now, the networking sessions will not be recorded, so you'll have the opportunity to turn your cameras on and ask questions then. But we want to begin by focusing on our fabulous speakers, so thank you all very much for kindly respecting this request. As always, I have the pleasure of introducing Jessica Rado, the architect and host of this fabulous webinar series. Jessica is a litigation and arbitration attorney based primarily in New York and Italy. She's a member of the Moot Alumni Association core team, where she serves as an editor of the Vindobona Journal and one of the coaches of the Fordham Law School Vismoot team. And so now, without further ado, let's get the show on the road. Jessica, the floor is yours.
Thank you so much, Mandy, as usual. Thank you, Careers in Arbitration, for hosting 1,000 Paths. I just want to also take a moment today to celebrate our wonderful founder, Amanda Lee, for her work with women in arbitration. For those of you joining who don't know, Amanda today celebrates the 100th post of her series, Women in Arbitration, which celebrates women all over the world in all capacity working in dispute resolution. Every week, she carefully drafts posts to celebrate their achievement, whether it's a promotion or a new role or an appointment to a committee. And today she celebrates this milestone, and we are very grateful for her work, and we hope that she keeps going in celebrating women all around the world. So thank you, Mandy. Going back to 1,000 Paths, it is my pleasure to host this episode. For those of you who are joining us for the first time, what 1,000 Paths does is it explores the various paths to pursue a career in international arbitration. We all know this is a competitive field. Sometimes it feels a little bit hard to get there. And we hope that through the series, we will all connect with professionals who have made it and who can give us some tips and encouragement on how to keep going and to reach our goals. So for each episode, we always have two practitioners, oftentimes at different stages of their career from different backgrounds, but they share a common theme. And the theme for today, as you all know, is how can I pursue a career in investment arbitration? So we have invited two wonderful guests who are going to tell us about how they navigated their careers in ISDS. Without further ado, it is my pleasure to welcome Cherine Foty and Faith Abel Abraham. Cherine is a senior associate in Covington's International Arbitration, ESG, and Business and Human Rights practices. She is dual qualified in common law and civil law. She spent several years working and practicing in Europe and is now based in Washington, D.C. She has experience in international commercial and investor state arbitrations, with particular experience in energy disputes. She also represents companies in a diverse range of non-judicial disputes involving human rights and environmental due diligence, global supply chains, and investor obligations. Cherine is the global co-chair of the Campaign for Greener Arbitrations, serves on the ICC Commission for Arbitration and ADR, and is on the board of Arbitral Women and is running for re-election, and we wish her the best of luck. Our second guest today is Faith. Faith is an international trade and investment lawyer at the World Bank. Filled with the passion for international law and dispute settlement, Faith left Nigeria in 2014 to pursue his legal education in Ukraine and Switzerland. He was trained in international law, European law, international trade and investment law, as well as economics. He also took part in a significant number of moot courts during his education to develop his advocacy skills in specific areas of law. Faith has a holistic background in international law and dispute settlement, having dealt with issues under public and private international law, state-to-state, commercial and investor state arbitration, and WTO law, amongst others. Faith has worked at different law firms and prominent international organizations in his legal career, such as WTO, the World Bank, and ICSID. Cherine and Faith, welcome, and thank you so much for joining us. We always keep our speakers' bios a little bit short because they tend to do way too many things for us to be able to list only one sitting, but we will post links to their full bios, and you can always reach out to our speakers after to learn more about the wonderful things they do. So enough about me speaking here. We're going to dive right into our questions. And as you know, 1,000 Paths, we always like to really understand what a job entails, what a day in the life of an attorney working in a particular field looks like. And so my first question for both of you is going to be this. Can you please tell us a little bit about your current roles and what, again, a typical day in your life and in your work life especially looks for you? Let's start with Cherine.
Okay, thank you so much, Jessica, and to Mandy as well for having me today. It's really a pleasure to participate in this webinar. So a typical day in my life consists primarily of international arbitration work. I do a mix of international commercial arbitration and ISDS, but as you noted from my bio, I'm also quite active in a new field, which is ESG and business and human rights, non-judicial disputes, which has some intersection with traditional international arbitration, but is also kind of its own separate path. I look at disputes which touch upon this field generally. So my day-to-day involves a mix of different things. Depending on what stage of an arbitral proceeding I'm at, I may be working on preparing perhaps a witness statement or an expert report for an upcoming submission. I may be reviewing a draft which has elements of research on a particular legal issue that would go in a forthcoming brief. I may be looking at factual assessments and putting together a factual narrative that is going to appear in a submission. Or I may be preparing for an upcoming hearing in which I am preparing witness cross-examination or preparing my own witnesses, or, expert reports or expert testimony as well, or preparing oral arguments, opening arguments, or closing arguments for forthcoming hearings. So depending on the stage, I may be engaged in those different preparatory activities. I may also be engaged in correspondence with an arbitral institution if it's an administered arbitration, or communication with opposing counsel on a particular issue. A lot of times there are procedural motions or requests that come up which are less foreseeable than your typical submissions that have some head time where you have a chance to prepare well in advance. Or a client may have an urgent need that relates to the arbitration. A lot of times we have things that come up that aren't necessarily the arbitration per se, but have a close relationship to the arbitration. So depending on what stage I'm at, what particular arbitration I'm engaged in, many of those different skills would come up in my day-to-day. In the non-judicial ESG and business and human rights work, I may be preparing some forthcoming submission, but in those disputes, there's a little bit more of an element of flexibility. So you do have a chance to deviate somewhat from a traditional kind of linear arbitration in which you have, each step of the arbitration follows a linear path. In those cases, there's ability to modify the procedure slightly, try to seek amicable resolution in another way, discuss potential mediation or stakeholder engagement in a different format. So all in all, my day-to-day is quite varied and depends on the particular circumstances of a case, but I would say it's never boring. There's always something interesting to do, and you feel quite engaged on a daily basis to have a diverse array of different tasks.
Sounds like a busy day, Cherine. Sounds like you have a lot going on. All right, crossing to a different office, still in Washington. Faith, what does your typical day look like at the World Bank?
Thank you, Jessica and Amanda Lee, for this opportunity to serve as a guest speaker in this webinar. So I work as an international trade and investment lawyer at the International Bank for Reconstruction and Development, which is an institution of the World Bank. On a typical day, my work involves reviewing domestic regulations, preferential trade agreements, PTAs, or otherwise known as regional trade agreements or free trade agreements, FTAs, and the WTO General Agreement on Trading Services, otherwise known as the GATT. In order to determine the investment climate of a particular country and recommend any improvements to facilitate international trade and investment in the country, we generally carry out in-depth research of the regulatory environment of the country. And this necessitates diving deep into the relevant laws of each service sector. Horizontal regulations essentially refers to regulations that apply across the board, and available dispute settlement mechanisms, and determining the restrictions that negatively impact international trade and investment in a particular country. And subsequently, we prepare reports on what to be improved in the country's regulatory regime based on international best practices. And this is a little bit different from the work I was doing while at ICSID, handling cases, case documents, and attending hearings when necessary. However, there is a mutual relationship between the two fields in that my principal work at the IBRD gives me exposure and gives me the necessary exposure of the domestic regimes of a particular country, which may have implications on international trade and investment. In essence, it serves as the basis on which investment disputes may arise.
Wonderful. Thank you both. Now I'm going to have a question for Faith. Faith, you have studied in all parts of the world, as we have briefly mentioned before. You have completed not just your first law degree, but a master's, an LLM, and a WTI diploma. And what do you think was the most useful course of study that better prepared you for your role first at ICSID and now at IBRD?
Academically, I would say the most significant program I underwent was my LLM in International Trade and Investment Law at the World Trade Institute, University of Bern, as it opened the door for me to many international organizations, which you just mentioned. Because during the course of the program, I had several courses, including international investment law and dispute settlement, latest developments in international investment law, as well as international economic dispute settlement. Apart from that, I wrote 2 theses on salient issues in international arbitration. The first one, titled The Establishment of a Multilateral Investment Court, Lessons Learned from the WTO. This leverages the knowledge of international trade law and international investment law. It assesses whether the use or the establishment of a WTO model multilateral investment court would serve as a remedy to the criticisms leveled against investor-state dispute settlement. For ICSID, this is relevant given the current ISDS reform project of the UNCTAD Working Group 3. And the second paper I wrote touched on my Ukrainian and Eastern European background, focusing on how the current geopolitical confrontations may have effects on investment in Russia and in Europe. It is titled State Execution Immunity and its Implications on Foreign Investment in Russia since the outbreak of the Russo-Ukrainian conflict. This is highly relevant given the difficulties investors around Europe may face to execute awards against state assets since the conflict in Ukraine began. And cases may arise at ICSID dealing with these issues, and a person having such a background serves as a very good candidate to work at the institutions. I believe that these factors played a key role for me securing my role at ICSID.
Fantastic. So we already have a lot of good advice to unpack there. Thankfully, our wonderful Mandy is summarizing some of the tips that our guests are giving us. So I would say the first takeaway, if one wants to pursue a career in this field, Faith seems to have the perfect academic background for that. So choosing the right LLM is one way to go. Research is another way to better prepare for the field, and generally diving into the issues and learning more and more, I would say, is the first common theme. Slightly switching gears and moving to Cherine. Cherine, in your role as counsel, which we understood keeps you very busy, you work both on commercial and investment cases. My question for you is, do you see any different skills needed for investment arbitration that maybe are not so crucial in commercial cases or maybe overlooked when considering just commercial cases?
Yeah, so I would say primarily there are more commonalities than differences. So a lot of the same skills that apply to putting together a case, kind of creating a factual narrative, ensuring that your storytelling is strong, and that the legal justifications support your storytelling. Those are common to both commercial and investment cases. A lot of the skill set is similar, kind of attention to detail, analysis in a compelling manner, creating, supporting kind of documentation and legal arguments to ensure that your case is comes across to the arbitrators in a compelling manner, and setting forth the relevant kind of legal authority to support those claims. What I think is slightly different in an investment context is the fact that you do have a bit more concentration on jurisprudence. There is, of course, a reference to the applicable law, which applies to international commercial arbitration cases, where you are, of course, referencing the relevant case law of the particular jurisdiction. However, in an investment treaty context, I think there's a lot more reference to international law and kind of cases and jurisprudence from previous international investment matters that can set a certain legal standard in a way that commercial arbitration deals with slightly different.
Thank you. I'm now switching gears again, a question for both of you. So investment arbitration is an ever-evolving field, and we always hear about the latest trend on an emerging area in ISDS. And what advice can you give to a young professional if they wish to keep up with new developments? I think we lost Cherine for a moment. Okay. Maybe Faith, can you take the question first?
Cherine is back.
Okay.
I'm sorry. Yeah, my connection cut out for a second. Can you hear me?
Yes. Yes. Still, let's have Faith have a go first. Thank you.
Sure. To keep up to date with the recent developments in investor-state dispute settlement, I would certainly recommend reading arbitral journals and surfing arbitration news portals or databases. Some of these include, for example, the Global Arbitration Review. And this publishes latest cases in ISDS, highlighting the background and decisions by various arbitral tribunals. These days, you may come across a range of cases relating to sanctions on energy and new approaches adopted by Russian courts to tackle the sanctions that have been imposed on several entities and since the outbreak of the Ukrainian conflict. And you may also consult IA Reporter, which is Investment Arbitration Reporter. It reports new developments in investor-state dispute settlement and publishes some arbitral decisions in full. And you can also check the portal of the UNCTAD Working Group 3. They just had their latest session, the 48th session in April in New York. You may come across the recent ISDS reform proposals, including the proposals for the draft statute of the Advisory Center on International Investment Disputes, and as well as the standing mechanism for the adjudication of international investment disputes, as well as the draft guidelines on prevention and mitigation of international investment disputes. You may also have a look at Jus Mundi. Jus Mundi particularly has a partnership with ICSID. So a lot of open ICSID cases are published on Jus Mundi. You can also find relevant articles or publications in the field of international investment law, as well as general international law and international trade law published on Jus Mundi. So it's good to pay attention to these platforms and portals, as you may find relevant news on the recent developments in arbitration on them.
Fantastic. Thank you, Faith. Cherine, anything you'd like to add as to how to keep up with new developments in ISDS?
Yeah, so I think in ISDS, as I mentioned, the importance of jurisprudence may be slightly more pronounced in that context. Not to say that in a commercial arbitration you're not applying kind of applicable law in a direct manner, but I think although we don't have a system of precedent in international arbitration and in ISDS, there is an importance on kind of established international investment principles that arise from the case law. So I would say that it's important to be privy to jurisprudential developments in that respect, to establish principles that other tribunals have recognized as kind of being the baseline for a legal assessment. To that end, where there are important developments in this kind of ever-changing landscape, it's important to have a good handle on what those developments are, to be able to use them either if you're representing an investor or a state to reinforce kind of your position on a particular matter. So to the extent there are new procedural mechanisms or an established new legal basis for a particular argument or defense, it's important to be comfortable with those arguments and understand what the current state of the law says on those particular questions. Of course, there is some room for creative lawyering where the facts of the case slightly differ, where you need to distinguish the situation or reinforce one particular element of a claim. So I would say it's very important to know about trends from an arbitration perspective, but perhaps what's even more important is being privy to trends in a particular industry, because as you are, depending on what your caseload looks like, you may have a concentration in one particular industry, or you may have, in my case, a diverse array of different industries that you deal with. And being able to convey industry norms and industry standards in the assessment of your particular factual situation is quite crucial to making the arbitrator's job easier. The arbitrator wants to place itself in the context of, what is the factual matrix in that industry that has pervaded. So I think it's important to stay up to date on emerging trends. And if I might add, in the context, not so much of ISDS, but in the non-judicial ESG and BHR space, it's extremely important to stay up to date on regulatory developments, because the landscape is changing so rapidly, and you need to have a good understanding of how the regulations are evolving in a way that you can adequately deal with both dispute prevention and the litigation or kind of ADR resolution of disputes.
Great. Thank you, Cherine. And following up on that question, and actually picking on something that Cherine mentioned, especially when one is first starting out in arbitration and still picking their LLM, or like still during their studies, choosing what courses to take, they are often given the advice that it's good to pick a specific area, focus on a specific issue, on a specific niche, how to call it, issue like mining or energy. So more than just investment, but like something more specific, more narrowed down, research it, become an expert on it, and really make it your own from the beginning of your career. So in your opinion, is becoming an expert on a niche area like this useful or essential or just recommended to foster a career in ISDS? And if that's your opinion, how do you think one should choose such an area to focus on? Let's start with Faith.
Sure. While I'm a type of person that would like to know a little bit about everything, I would certainly recommend specializing in a particular field of interest if there's an opportunity. Keyword, if there's an opportunity. This is because it presents you with a number of benefits. First of all, it presents you with expertise, and recognition. Having expertise in a particular field sets you apart from generalists, which only have general knowledge without in-depth knowledge of a subject matter. In this regard, you'll be a go-to person when a complex dispute arises, and this also enhances your reputation. It also opens unique career opportunities for you. For example, in arbitration, there's constant demand for consultancy, advisory roles, and expert witness positions. And as well, it also increases your chances of networking and having influence in a particular field, because you are able to build a network of contacts with people with whom you share common interests, which could lead to collaborations, referrals, and influence within a specific field of arbitration. Now, there's also a tendency for you to engage in impactful work. By focusing on a particular field or niche, it allows you to contribute more significantly to a field by addressing specific challenges and developing innovative solutions. Consider, for example, the current work of the UNCTAD Working Group 3 on ISDS reforms. Various experts have put forward proposals on the reforms which are currently being used or currently being discussed at the UNCTAD negotiations. And with regards to choosing a niche, I would say, first of all, you need to consider an area where you have interest and passion. This is because when you choose an area where you have interest and passion, you are able to sustain a motivation to continuously grow in that particular field and try your best to excel. However, you should also pay attention to industry demand, because sometimes you may have interest in a particular field, but there may not be a lot of cases and you wouldn't like to be out of business. So pay attention to current trends, regulatory changes, or as well as emerging challenges. Also take into account your strength and background. What skills do you have? What educational background do you have? And work experience. When you leverage all of that, it is easier for you to establish yourself as an expert in a particular field. Take into account the future trends. What areas of law or what areas of disputes may likely be hot topics in the future. For example, these days, if you look at the developments around the globe, you could see energy would still be prevalent, renewable energy, digital economy, as well as technology, and maybe hot topics in the future. Then also get yourself a mentor who would be willing to give you all necessary guidance, as well as try to find all access to relevant information on a particular field, which would help you deepen your knowledge and develop. This would essentially help you to become an expert in time.
Wonderful. Cherine, what's your take?
Well, Faith, those are all fantastic tips. So I would encourage our audience members to really take note of all of those. I would just add two points. Number one, I think there is a benefit to, there's a balance between hyper specialization and familiarity with a broad range of issues and topics. From my perspective, I've been more of a generalist, but who has some expertise kind of from repeat types of cases. So on the one hand, I had this broad view of many types of cases and industries and legal issues, but at the same time, I've had the opportunity to kind of specialize in a particular field. And now with my concentration on ESG and business and human rights disputes, I've certainly established an additional specialization in that field. However, I do think it's important to also keep abreast of developments from a general standpoint. You never know what is the, although you may concentrate your business development efforts in along one path or another, you never really know what the next case is going to be. So I think it's important to keep just a baseline kind of knowledge and kind of familiarity with different types of cases that may arise. I do agree completely with Faith that there is a benefit in establishing your particular niche, and if you're able to do that, I think it's something which can distinguish you at an earlier stage of your career from your peers. So if you have this baseline general familiarity with arbitration trends in various industries and kind of the general sense of the market, that's important. But you will go above and beyond if you're able to additionally say, I know about EU ESG regulation. I know the deforestation regulation, the CSDDD, the CSRD. I'm familiar with all of these things, and I'm your go-to person if there's a dispute in that field. Or I know the latest developments in AI, and I can tell you, back and forth what's going on in AI. I'm, consult me if there's an issue in this field. So I think it's really important to do both and to adopt that balance, because if you're entirely hyper specialized in a field and you don't have that baseline knowledge, then you won't be seen necessarily as a reliable practitioner for someone who has that baseline knowledge to be able to handle a variety of disputes. And that's also important in our field, where we may not have the opportunity to hyper specialize. So I think a good balance is important. One last point, which is that as you are specializing, it's important to also, you do want to be aware of the trends in a particular specialization, but I think what is important is the substantive knowledge that goes along with the litigation of disputes. So you do want to go to industry conferences. You want to interact with the commercial individuals that are involved in these particular issues. You want to get a good sense of what the business landscape looks like, because that context is going to be immensely important in how you're conveying a particular legal or factual issue that comes up in a disputes context.
Wonderful. Lots to unpack there. I hope everybody's taking good notes. I know Mandy is. But thank you both for wonderful advice. Moving along, I know I have many questions, but bear with me. One more question for Cherine. So in your practice as counsel, Cherine, you regularly act as counsel for investors as well as for states. And my question for you is there a need for different skill sets in the two roles? And what are some things to keep in mind when acting for one or the other? And again, focusing on starting out in the field, what do you think? You've already told us there's a lot of overlapping between different industries in arbitration, but perhaps do these two roles have any differences you think it's worth highlighting?
Yeah, thank you for that question. So I would say, once again, there are a lot of similarities between the two, even though your orientation and position is quite different, depending on whether, especially in the ISDS context, between whether you're representing an investor or a state. There are a lot of common skill sets, and I know that there are some firms that kind of only do state representation or only do investor representation. And I think I've actually found it quite beneficial to do both, because you understand the flip side of the potential arguments, and you can anticipate counter arguments in a way that you might not be able to do if you weren't as familiar with that position. So I do think that from the state perspective, your orientation is different, because you're obviously defending state actions or regulatory positions in a way that from an investment context, you're from an investor's standpoint, you wouldn't be doing. You would obviously be attacking a particular measure that may have been taken. So it's the way in which you approach the case is quite different, and the framework in which you evaluate a certain decision is going to be obviously quite different based on the various considerations that go into a treaty, a bilateral investment treaty, or into the legal framework of the relevant state. So I would say in terms of skills that are different, I think a lot of the skills are the same. It's just the orientation which is different, and the starting point, the standpoint that you're approaching it from, but the skills are quite similar. For instance, you know, you're looking at applicable legislation, you're looking at the processes and the procedures that were followed, you're engaging in an analysis of the relevant facts and pulling out key details. You're looking at potential defenses or even counterclaims now in many instances that a state potentially could bring. From an investor standpoint, you are looking at, you know, all the various bases that are set forth in a treaty and in the ISDS framework that would allow you to show that an investment has somehow been affected. And but the commonalities are, you know, I think more pronounced than the differences, where you're critically looking at an investment and the decisions that were made vis-a-vis that investment, and presenting kind of a compelling factual and legal argument on that basis.
Very interesting. Thank you. Seems like I keep looking for differences that are just not there today. But no, thank you very much. That was very thorough and very useful. I'm switching gears again, asking kind of an off-topic almost question to Faith. And the reason why I want to ask you this, Faith, is sometimes I think when one wants to pursue a career in arbitration, we tend to focus on the obvious: counsel or just at an arbitral institution. But the word of arbitration and investment arbitration, trade law, is very, very big, and there's many opportunities. And in your path, you have experienced a bunch of different ones. So I wanted to take this opportunity and ask you, given your experience in different capacities at the World Bank, if you can maybe give us a little bit of an overview of this organization, the branches, and what might actually be some, I want to call them less obvious opportunities, but maybe they're just less obvious to me, I don't know, that the World Bank may offer for young attorneys.
Sure. Well, for those of you who aren't familiar with this fact, the World Bank consists of 5 institutions rather than just one, because initially that was also my understanding, that there was only one World Bank in the past until I got to work in the institution itself. There are 5 institutions of the World Bank. The first one is the International Bank for Reconstruction and Development, also known as the IBRD. The IBRD provides loans and financial assistance to middle-income and credit-worthy low-income countries. The second one is the International Development Association, which offers concessional loans and grants to world's poorest economies. Then the IFC, which is the International Finance Corporation. It provides loans, equity, and advisory services to stimulate private sector investment in developing countries. Then one which we may be familiar with, Multilateral Investment Guarantee Agency, which is MIGA. It offers political risk insurance and credit enhancement to investors and lenders to facilitate foreign direct investment in developing countries. And one which we are all familiar with is the International Center for the Settlement of Investor-State Disputes, which is ICSID. It facilitates conciliation and arbitration of international investment dispute. These institutions are collectively known as the World Bank Group. And the term World Bank traditionally is used to refer to the IBRD or the IDA, or both of them. However, recently it's used to refer to the entire collection of the institutions. Also note that while there is a link, or yes, there's a close relationship between the International Monetary Fund, IMF, with the World Bank, IMF does not fall within the collection of World Bank institutions. With regards to the overview of the branches and the opportunities, I would like to focus on the institutions that I worked in, the IBRD as well as ICSID. With regards to IBRD, young lawyers may be able to work on drafting and reviewing of loan agreements, advising on compliance in international law, and ensuring projects meet environmental and social standards. Lawyers may be able to work in the legal vice presidency unit, as well as the ethics and internal justice units. However, if one also has very good knowledge of economics, he may be able to work in DEC or the Ethereum units, which are essentially units that deal with macroeconomics, trades, and investment. So the more you are able to have knowledge of different fields, the better for you to have work at the World Bank institution, specifically the IBRD. With regards to ICSID, this is more of a lawyer institution. So there are more opportunities for you there. As a young lawyer, you can serve as a paralegal, a legal assistant, a consultant, or an analyst on arbitration proceedings, conduct legal research and draft procedural orders, and as well support case management. There are different kinds of contracts within the World Bank, which generally depend on the number of days you are allowed to work. So there's an STT, the STC, the ETT, the ETC, and finally the staff position. One very good factor working in the World Bank is you have a possibility to work in different institutions at the same time. So you can secure a contract in IBRD and at the same time at IFC. So you'll be able to allocate a number of days you work for each institution if there is a compatibility, because in some cases, some institutions may not allow you to work at a different institution due to conflict of interest. For example, sometimes it may be difficult for you to combine work between ICSID and IBRD, especially if it relates to a particular country. One specific country, say for instance, you are dealing with a case on Azerbaijan at ICSID, you would not be allowed to deal with issues related to Azerbaijan in IBRD. And some opportunities are exclusively advertised for those who are already within the system. So if you are a consultant, you have the possibility to grow within the system. And these opportunities are not open to the general public. With regards to how to pursue these opportunities, if you are at an early stage of your career, then you should consider applying for World Bank internships, because that's generally the way to get into the institution, particularly in the legal vice presidency. There's an opportunity to grow from a consultant, or from an intern, you may be able to graduate to a consultant subsequently to a staff. In that unit, it's very difficult to come in as an outsider. Then engage with experts who currently work at World Bank. Sometimes they may be engaged in projects which may require some external expertise. You may be offered a chance to come work in some of the projects, because due to the nature of the contracts, you may be called upon to work on projects which may last between days or even up to years. Then I would also say that the knowledge of language, foreign languages, is very important if you want to work in the World Bank. I think this is an essential factor, not only at the World Bank, but international organizations in general. If you have knowledge of different foreign languages, you are able to secure opportunities there ahead of someone who may have a comparative level of knowledge and skills. And one thing I would like to say is that applications, when applying to these institutions, okay, you should have hope in getting in, but you should not put your full hope in getting in, because it's very competitive. It's highly competitive, and some of the factors that they look into go beyond your control. For instance, the recruitment criteria. For instance, if you apply for a job and someone applies for the same job and you have a comparative level of experience, as I mentioned earlier, language knowledge may set you apart. And if you do look at the conditions between candidates, for instance, one who grows up in Europe has a tendency to have knowledge of many foreign languages in comparison to someone, say, from Africa, who may only have knowledge of maybe French or only knowledge of English. So this sets you apart. If you have the chance, I would highly recommend learning, for example, Spanish, French, in addition to English language. And second, you should also take into account that internal candidates within the institution may be more familiar with the work that is being advertised. And so you shouldn't really get angry or feel embarrassed or lose confidence in yourself when you are not called for an interview and you are not accepted as the candidate. Some factors are really taken into account, that is the familiarity with the work and also the relationship perhaps with the hiring manager. If I have a good relationship with you already and I'm familiar with your work, that's a high tendency that I would wish to proceed with you in that particular work. CVs may be deceptive. Someone may put forward a very good CV and you may be captivated by it, but when the person begins to work with you, you may get to discover their weaknesses, or they may not be able to do the job effectively. So you may have to understand the apprehensions some of the hiring managers may have when it comes to external candidates. It's unfortunate, but that is the reality.
It sure is, and unfortunately, not just the World Bank. I mean, yeah, for those kind of instances do happen in many places. But Faith, thank you so much for that overview. I found it very helpful to get a better understanding of the World Bank, and some really great tips for whoever is looking to get an entry-level position and to get started in these roles. So thank you so much. In the interest of time, since we do want to keep a few minutes for questions, I'm going to skip to the last question. And I'm going to ask to both of you, what is the single best piece of advice that you wish you were given when you were first starting out in this field? Let's start with Cherine.
Thank you. So I would, there's a lot of advice that can be provided, but I think what I would have liked to understand earlier is that you mold your career, and a career is not kind of a single achievement. It's really bits and pieces and pathways and deviations and changes and taking on new interests and something that's dynamic and ever changing. And so while a first kind of professional role can really feel like it's the end all be all, it's really important to keep in mind that career is a long path that has a lot of room for being molded into something that you may that may not be what exactly you had envisaged at the outset. So one piece of advice that I would have liked to know is just keeping an open mind as to how you move along that path, and taking opportunities as they come as a means to constructing your career, as opposed to being focused on one particular type of achievement and only focusing on trying to achieve that particular step. There are so many different ways that you can create your career. If the opportunity doesn't present itself, create your own opportunities, create your own fora, create your own events and programs and publications, and you will create your career in that fashion. So I encourage you all to be open-minded in that respect. And if certain opportunities are not available to you, just keep trying and create other possibilities for yourself to excel.
Fantastic advice. Thank you, Cherine. Last but not least, same question to you, Faith. Even though you've already given us plenty of advice, what is the single best piece you wish you knew at the beginning of your journey?
If I would advise someone today, I would advise that person to develop strong cross-disciplinary knowledge and skills. This is because it presents you with several advantages. Given the complexity of ISDS disputes today, which involve a wide range of issues, including international law, domestic law, finance, and industry-specific knowledge such as mining, energy, telecommunications, and technology, it's highly important to develop cross-industry or cross-disciplinary knowledge. This helps you to have a broad understanding of the areas and can greatly impact your ability to navigate and understand the complexities of each case. As well, it allows you to approach a case from multiple perspectives, making your analysis more comprehensive and insightful. And finally, I would like to say that being able to speak the language of different disciplines helps you to communicate more effectively, for example, with stakeholders, your clients, and experts from different backgrounds.
Fantastic. Thank you, Faith. Thank you both. This has been a wonderful chat, a wonderful discussion. We are at the end of our questions. We're going to move to our Q&A in a moment. But before we do that, since the Q&A will not be recorded, we're going to wrap it up for recording purposes only. So I would like to first thank our speakers for joining us today and for the wonderful advice they've given us and for sharing their journey, which has been absolutely a delight to hear. And I would like to give the floor back to Mandy for closing remarks.
Thank you very much, Jess. Well, thank you to our fabulous speakers. I can only echo Jess's thanks in this regard. Your advice has been very practical, very sensible, and very thoughtful, and we are very grateful to have you both here with us today. Thank you very much to our audience for tuning in. As Jess has mentioned, we will now be ending the recording.